my name is Dela Yemiban. I'm your export doctor. Thank you for stopping by on this YouTube channel, the Global Trade Tutor. In today's video, I will continue the conversation we started for a while now, talking about export contract, what no one tells you about export contract. Today, we are looking at dispute resolution. Today, we are looking at dispute resolution. Dispute resolution. There will be challenges and disputes in most contracts. Sometimes it's inadvertently happening. It's important for you to define how you are going to resolve it. This resolution section of export contract outlines the procedures, the mechanism, the avenue for resolving dispute that may arise between the parties during the performance or interpretation of the contract. This section is essential for providing a structured and orderly framework for resolution of disagreement, minimizing risk of protracted dispute, and preserving the parties' commercial relationship. When issues are resolved amicably, relationships are preserved. So I will talk about negotiation of this dispute, mediation, arbitration, litigation, and escalation clauses, confidentiality, enforcement of decision, costs, and expenses. Negotiation. The contract may require the parties to attempt to resolve dispute amicably through negotiation before pursuing more formal dispute resolution mechanisms. The negotiation process may involve discussion between designated representatives or senior management of the parties with the aim of reaching a mutually acceptable resolution. So, negotiation. That's conversation before in the party, before bringing a third party. The negotiation process involves discussion between the parties and their representatives. But you can decide to do mediation. The contract may involve mediation as a voluntary or non-binding form of dispute resolution in which an impartial third party form a dispute resolution. So an impartial third party facilitate negotiation between the parties to help reach a settlement. Mediation can be an effective way to resolve dispute informally, confidentiality, and cost effectively. It can help to resolve the dispute informally. It can help to reduce the dispute confidentially and also cost effectively, because when you go to court, it's no more confidential. It's already in public domain, while preserving the parties' business relationship. Arbitration is a commonly used alternative dispute resolution mechanism in international contract. The contract may require the party to submit dispute to arbitration, which involves referring the dispute to one or more independent arbitrators who render a binding decision known as the arbitral award. The contract should specify the arbitration rules, number of people in the panel, the language to be used, if there will be need for appeal of the panel, procedure, the seat of arbitration and location, the governing law that guide the arbitration process, the language of the arbitrator, as well as limitation on the arbitrator power or remedy available. The last phase, litigation. In some cases, the contract may provide for dispute to be resolved through litigation in a court of law, and that will state the governing laws and jurisdiction. This is where you need your lawyer. I'm not a lawyer, but I study international business law. That's why I could talk about this. But it's still good to involve your lawyer, particularly for different country laws. If you have to choose a country, sometimes people choose neutral location. Okay, there was a time we went to sign the contract with a Chinese firm. The Chinese firm wanted arbitration or litigation to happen in China. We wanted it to happen in Nigeria. The other party wanted it to happen in China. We wanted it to happen in Nigeria. So we have to reach a compromise, agree on a neutral location. You agree on a neutral location where this was going to happen. And eventually we chose London International Court of Arbitration in London. I think it's London Court of International Arbitration. You can also choose International Arbitration, ICC Arbitration Court in Paris. Either of those two. Now, in some cases, litigation may involve, some cases, contract may involve, may provide for dispute to be resolved through a court of law. The contract should specify the jurisdiction, the venue where legal proceeding will be initiated, as well as the applicable law, governing law and jurisdiction. And interpretation and enforcement of the contract. Litigation is typically considered as last resort. Remember, negotiation between both of you, mediation, you brought in a third party to assist, arbitration, you now formalize it and get an arbitrator to do it, and then litigation. Litigation is typically considered as the last resort of resolving dispute due to the adversarial nature, complexity, and of course, potential cost, legal fees. So, escalation clauses. The contract may include escalation clauses that outline a step-by-step process of escalating dispute to higher level of management or dispute resolution mechanism if initial attempt and resolution are unsuccessful. Escalation clauses help to ensure that disputes are addressed promptly and effectively at the appropriate and organizational level. Addressed promptly and effectively at the appropriate and organizational level. So if you put an escalation clause, when there are issues, it's easy to escalate. So you say in this contract, escalation clause helps to ensure that the disputes are addressed promptly and effectively. So it prevents issues. In fact, it prevents the issue from degenerating to an irreparable level before it's escalated. So it might involve clauses that outline the step-by-step process for escalating dispute to a higher level of management and dispute resolution mechanism. So maybe I send a mail, within a week I didn't get a response, I send it to the next level, maybe of the management, from the lower level of the officer to the management, from the management to the senior management, or even the owner of the business. This is very, very important. Contract should include provision requiring parties to maintain confidentiality of the dispute resolution proceeding and related documents to protect sensitive information and preserve the parties' commercial interest. Very important. Enforcement decision. The contract should address enforceability of the dispute resolution decision, whether through arbitration award, settlement agreement, court judgment, and specify the parties obligated to comply with such decision within the specified time frame. And lastly, cost. The contract should specify how the cost of litigation, the expenses associated with dispute resolution, the arbitration fees, the legal fee, the expert witness fee will be allocated between the parties. This may include provision regarding payment of cost by unsuccessful parties or sharing of costs between the parties involved in the contract. The idea is this. This is the last resort. This is the last resort. This is the last resort. You want to find a way to mitigate, to prevent this from happening as much as possible. I will sacrifice anything required on my part to ensure this does not happen. Sometimes it might require me incurring some cost, but save time, energy, and preserve the relationship. As an exporter, you need your buyer. International trade is buyer's market. Buyers have so many people that want to sell to them. So you want to preserve that relationship as much as possible. Even though I've talked about all these legalese in this series, sincerely, depending on what the buyer wants, you might not necessarily go all the way in putting all the, you know what I mean. But if you're dealing with someone for the first time, maybe as the relationship progresses, sometimes you might want to loosen up. Because that means you get to a level that even when there are issues, you will resolve it. You find a way to resolve it amicably. So because international trade is built on trust, and that should guide your business decision. Thank you very much for this series. We'll be continuing other series later on, but thank you for following us up to this point. If you have followed the series up to this point, My name is Delaim, but I'm your export doctor. If this video has been of help to you, give it a thumbs up. If you have a friend that needs to hear about this, that needs international trade leader, import or export, share with your friend. By the way, this video is not just for exporters, it's also for importers. Share with your friends. And more importantly, let me have your question and comment in the comment section. My name is Delaim, but I'm your export doctor, and I'm signing out.